believe you're entitled to 10 minutes of oral argument. If you wouldn't mind putting your name on the record, please.
I'm the executor and sole beneficiary of the trust and estate of Mr. Kevin Dwayne Craft, the legal persona.
So today's contender in the Sovereign Citizen Hall of Fame is Kevin Dwayne Craft, a man who decided that accountability was optional and logic was negotiable. Welcome back to the channel, everyone. In this video, we're breaking down a sovereign citizen who didn't just argue with a local judge or file a stack of nonsense motions, but actually marched his case all the way to the Michigan Court of Appeals, not to defend some imaginary right to travel or claim he isn't a real person, but to argue that the state has no authority to make him support his own children. Yes, that's the hill he chose to die on, dressing up deadbeat behavior in pseudo-legal jargon and hoping a higher court would fall for it. So get comfortable, because this case is a perfect example of how confidence without comprehension can turn into a full-blown legal disaster, and we're about to walk through every bit of it.
I'm not here making a general appearance. I'm here by special divine appearance, judge, to settle a matter, to call for a constitutional court of record to ask for a summary judgment upon the truth and facts that I placed upon the record with my documents. I stand firmly on my rights, and I'm here to ask for the summary judgment, please.
You asked for.
I do also have a few questions.
I understand you're pro se, and then therefore you get a little bit of leeway, but typically the judges don't answer questions. We're the ones who ask questions. This isn't like a trial court where it's a very kind of back and forth. The Court of Appeals is more structured in terms of the lawyers or parties come up, they make their arguments. The judges may or may not have questions for the person, and then it's submitted, and then we go back and discuss the matter, and then at some point in the future we come out with an opinion. So it is different in that respect than trial court.
Understood. But I am wondering if this is a court of constitution, and would the Constitution be applied in these proceedings?
The Court of Appeals, the Michigan Court of Appeals, is provided for under the state Constitution of 1963.
Is that a yes?
That's the answer I'm giving you.
Okay. I'm asking to verify to make sure these proceedings are legitimate. The Constitution has two jurisdictions: common law, admiralty law, or maritime tribunal. And I'm asking in which context would this court try to enforce jurisdiction on me?
Hold on for a second. You are the one who personally dragged this case all the way to the Michigan Court of Appeals, and now you want to stand there and question whether they have jurisdiction over you. That argument already collapsed the moment you filed the appeal. And to answer what you keep calling context, the court's authority over you is not some mystery loophole. It is grounded in both personal jurisdiction and statutory law, clearly established under the United States Constitution and reinforced by the Michigan State Constitution. So once again, this court did not stumble into your life uninvited. You asked them to review your case, and now you are bound by the very system you tried to challenge.
We're acting under the state Constitution of Michigan of 1963.
Moving forward, I'm here to pretty much address the court's error for ignoring my motions. Notice of dismissal, default judgment under Federal Rule 55 was filed December 12, 2022. Under Federal Rule 55, if a party fails to respond to the defendants themselves, and this is confirmed by my affidavits and other means, the clerk must officially record a default judgment of that party. I filed several motions and they were ignored. That's why I'm here. In Haynes versus Kennar, 404 U.S. 519, 1972, courts must be understanding and not easily reject motions from people just representing themselves. And that's what took place in this matter.
But is it really though? Because in Haynes-Kerner, the courts made it clear that claims of civil rights violations cannot simply be tossed aside without at least giving the claimant an opportunity to present supporting evidence. And I'm sure in your case, you filed a mountain of frivolous motions, all of which were promptly and correctly denied. And somewhere along the way in that delusional fog of sovereign logic, and blissful pain huffing you convinced yourself that being told no by a judge is the same thing as suffering an actual constitutional violation, which it absolutely is not.
In Article 1, Section 17 of the Michigan Constitution prevents courts from ignoring motions and guarantees that people have a fair chance to represent themselves in any argument and evidence. That did not happen. That's why we're here. The state ordered me to take a paternity test. And Monell versus Department of Social Services, which is a New York State case. The Supreme Court case established that municipalities' liability under the Section 1983 for constitutional violations in the context of child support cases, where the appellant argues that a warrant should be required for me obtaining genetic and biological material. I think it's very sensitive when a state injects an order asking me to give genetic and biological material without a warrant. That's really sensitive material. It's not like a document or anything. That's personal biological material. That's why those specimens were not granted. That's why I deny any consent or any contract with the state or Title 4D agency to give away my biological and genetic material.
Oh, so now it all makes sense. This was never about rights or jurisdiction or the Constitution. This was about you not wanting to take care of your kids and pay child support. So instead of stepping up, you went full sovereign citizen mode, convinced yourself the law doesn't apply to you, wrapped it in fake legal theory, and marched into court thinking you'd found the ultimate loophole, when in reality all you did was turn a basic responsibility into a public legal embarrassment.
That the case Monell is relevant because it underscores the importance to ensure that government agencies like the friend of the court on this context. These are for-profit agencies disguised as government agencies like the friend of the court, adhere to constitutional standards where collecting evidence potentially implying the need of procedure safeguards to protect individuals' Fourth Amendment. That's why I asked, was this a constitutional court? The asking for genetic material is protected by my Fourth Amendment right. The Fourth Amendment protects individuals from unreasonable searches and seizures and safeguards one's privacy and assurance that any such search is conducted within the boundaries of legal requirements.
Well, there's your first problem right there. Michigan Compiled Laws Act 205, better known as the Parenting Act, already spells this out in plain language. It gives the state clear legal authority to require DNA testing. In cases like this, it outlines exactly how that DNA can be obtained, explains the procedures the court follows, and it even lists the consequences for refusing to participate. So this isn't some secret overreach or surprise ambush by the government. It's codified law on the books and has been for a long time. Whether you like it or not, the statute answers every question you're pretending is unresolved.
I see that they're not here today, and that's some questions that are raised, and those were my concerns. On August 11, 2022, the Kent County ordered an appointment for me for genetic and biological testing. In a testing laboratory, DNA Diagnosis Center is a business, and I can prove it's a business because I have their Dun and Bradstreet numbers, 877-184226 for the record. They also said, when I thought this was funny, the state of Michigan stated that it would pay the cost of the genetic test. And if I wasn't excluded, that I would be responsible for that cost. And with that being said, that set alarm.
Let me guess, that's when the oh no alarm started blaring in your head, the moment you realized this was about to cost you more money. And despite all the paper terrorism and fake legal magic tricks, the court was still going to confirm what everyone already knew, that you are in fact the father, and no amount of sovereign wordplay was going to change biology statutes or your obligation to support your own kids.
The state of Michigan is also a business. And with them fronting the cost for me, that presented an alarm for me because I don't choose the contract with the state of Michigan. I don't choose to do business with them in this regard with another business. It seems like a coercion of some sort for them to upfront the cost if I was going to be responsible. I do not consent to that business arrangement. The state, they failed to show a promissory note of a contract of any sort. I submitted documents, notice to the court to demand dismissal for lack of jurisdiction, demanded to see an open court evidence of personal and subject matter jurisdiction, and notice of court to refusing to appear voluntary. And I do not accept the offer to contract, and I do not consent to these proceedings. That affidavit or notice to motion was submitted on November 28th, 2022. So again, I'm just bringing up the point that I submitted numerous of documents asking for clear evidence or asking for due process, also asking for just quite frankly, to be transparent with what's happening. And I believe I deserve the right to see in writing what gives them the authority and what contract am I entering. I want full disclosure.
Asked and Answered Michigan Compiled Laws Act 205 already provides full transparency on this issue. It clearly lays out the legal authority of the state, the procedures used to administer paternity testing, and the consequences for refusing to comply. There is nothing vague, nothing hidden, and nothing unconstitutional about it. The statute answers every question you keep pretending is unresolved and completely undercuts this entire argument before it ever gets off the ground.
In Burns 322 BR 719, a creditor must provide proper documentation such as a promissory note, contract to substantiate a debt or court claim. They did not. More documents I filed. Affidavit inserting corporate nature of government entities. I submitted that document because I'm concerned that these are for-profit businesses disguised as government agencies. You know, I have proof. Kent County Court, Dun and Bradstreet number for the record, 152906082. Kent County Friend of the Court, Dun and Bradstreet number, 6088333133. State of Michigan, Dun and Bradstreet number, 504698428. These are businesses. I would like to state for the record that I am not a corporation.
Yeah. No, you're not a corporation, and honestly at this point, I'm about to hand this guy the stupid dumb information I didn't need to know today award, because the things he's insisting on arguing are just wild, pointless, and completely irrelevant to reality. I mean, we've gone from pseudo-legal theories to full-blown denial of basic responsibility, and somehow he's still acting like he's dropping knowledge bombs when really he's just collecting shame points.
I'm a living, breathing person, human being. With these being businesses, they have to abide by the same rules as other businesses. And may I give an example? For example, McDonald's. McDonald's can't force me to eat their Big Macs. They need my consent. None of these businesses that I've mentioned have my consent to do business with them. Section 458 of the Social Security Act, incentive payments to state. It's a conflict of interest. And it's my argument right here, right now, that the state incentivizes them it incentivizes them to collect more child support.
What the heck do you think happens when you pay child support to the state? It doesn't vanish into some magical debt collector account or get sold off like bad credit. The money goes to the guardian. That's right, the state acts as a neutral mediator, not a payday buyer. They make sure that the support you legally owe actually reaches your kids, so all that whining about the state taking my money is just nonsense. The system isn't out to screw you, it's out to enforce your basic responsibility as a parent.
The main argument I have here and for you guys is full disclosure. You know, it seems like they enter me in a contract without my consent, without full disclosure, and that's the problem here. You know, I'm here to argue subject matter and lack of jurisdiction. No evidence was established in my involvement of a common law crime or damages, and I did not commit any common law crime. Notice of court to refusing to appear voluntary, and I do not accept these contracts, and I do not consent to these proceedings was another motion or notice to motion that I submitted 11/28/22. And It's basically it's evidence. They didn't provide any evidence of an injury or injured party. And
Mr. Kraft, you're out of
Yes.
time. We understand that you raise issues of disclosure,
yes,
jurisdiction, remedy, and as I indicated, your brief, as with all the appellants and appellees we have here today, the briefs that you submit are kind of the key issue or the key tool that we use to resolve cases. And so I just want you to know, we have your brief. We're going to go back. We've had research attorneys look at it. We're going to look at it again. We're going to discuss your case. And then you'll get an opinion from us sometime within the next few weeks.
if I may, one last thing.
You've got, if you can do it in 20 seconds.
I can. The government must prove charges beyond a reasonable doubt with clear evidence, especially when making the claims against someone. And I'm asking you guys right here, right now, they did not provide any evidence against me. And I would ask you to dismiss this without prejudice.
All right, so I'm going to assume the long answer and the short answer are exactly the same. Nope, that's it for today's video. The judge said a decision will be issued in a couple of weeks. And as soon as it's public, you better believe I'll be there to cover the sovereign citizen's epic loss. So if you enjoyed the video, drop a like. If not, hit dislike. But don't forget to comment below and subscribe with notifications on so you never miss any of my content. I'm Team Saju Shah, and I'm out.